Perfect. And so I'd like to welcome everyone once again to today's workshop sponsored by the Wisconsin Special Education Mediation System. Today's workshop is going to focus on the option of mediation. It's important for parents and school staff to resolve their issues right away when they arise. This webinar is going to include information about the free mediation services that are available from the Wisconsin Special Education Mediation System. And that is a mouthful, so we oftentimes shorten that to WSEMS. So if you hear either myself or my co-presenter Nissan using the shortened version WSEMS, we are just referring to the mediation system. So we're going to give you some information about the system. We are going to provide you with some information related to the federal and state laws surrounding mediation. We're going to provide you with information on when and how to request mediation, who the mediators are, some tips on participating in mediation, and much more. Our presenters today are Nissan Barlev and myself, Courtney Selzer. Nissan Barlev is the CISA 7 Director of Special Education, and Nissan is one of 3 partners who help to administer the WSEMS. Nissan represents the school perspective on our team. My name is Courtney Selzer. I'm the Executive Director at Wisconsin Facets, and my role is to represent the parent perspective on our WSEMS project. So with that, we will move on to the next slide. On this slide, you've just got an agenda of, again, some of the things we're going to cover today. So we're going to provide you with information about the mediation process that is available from WSEMS. We're going to start by giving you an overview about the system itself, and we're going to briefly talk about the various other options that are available for dispute resolution through this system. Next, we're going to move on and cover what happens before, during, and after a mediation. And then we're going to finish things out today with some outcome information that we've been gathering from WSEMS mediations for many years now that can help show you how effective the system is for helping parents and schools resolve their special education disputes. Did just want to take one moment to mention that currently the WSEMS system is in fact conducting mediations both virtually and in person. And so we just want to put that out there early on in the presentation so that people are aware of that. With that, I will turn things over to Nissan.
Thank you, Courtney. Good afternoon, everyone. The Wisconsin Special Ed Mediation System, WSEMS, as Courtney mentioned, has been funded by the Wisconsin Department of Public Instruction with a federal grant to CISA 7 since 1996. And for all these years, the goal of the grant has been to administer the Wisconsin Special Ed Mediation System throughout the state. This means that to provide a roster of neutral to assist in the resolution of disputes between parents of student disabilities and schools, to provide training and outreach about the system, just like the presentation that we are doing today, and to collect longitudinal data for ongoing evaluation of the system. This is our way of quality control of our system. WSEMS is a unique system that has been nationally recognized by the Center for Appropriate Dispute Resolution in Special Ed, in short, CADRE. It is an agency funded by the U.S. Department of Education. WSEMS was recognized as one of just 4 exemplar state systems that were considered extremely effective in its usage and outcome, meaning high agreement rate in mediation. WSEMS was also selected because of our successful involvement of stakeholders, and you can see the exemplar booklet in your handouts. Our system was designed by a 17-member group of key stakeholders back in 1996, half of them representing parent groups and half of them school groups. The WSEMS Stakeholders Council still exists today and continues to serve as a collective advisory body for our system. Our system is also unique nationally because it is led by a team that models partnership and provides oversight to the system and includes a school partner, that's me, and I represent the school perspective on our partner team. And I'm also one of the founder of WSEMS, along with Courtney Salazar, the Wisconsin Facet Executive Director, who is a parent of 2 young children and represents the parent perspective on the team. Gia Pionic, an established mediator, serves as the mediator partner and represents the dispute resolution expertise that's needed on our team. Gia is also the system administrator and intake coordinator. So when you call WSEMS, she is the person who you speak with about your concerns and issues. She explained what is involved with mediation or IEP facilitation, assign cases to the mediator and facilitators throughout our system. Now, Narcinia Ramos is a parent and is the Associate Director of Wisconsin Facets, and she's also our WSEMS multicultural outreach coordinator. So besides the high agreement rate that we mentioned earlier, intense stakeholders involvement, in which WSEMS was nationally recognized, Wisconsin also was one of the first states to provide IEP facilitation, an option that is not required by IDA 2004. We believe simply that more options available for school and parents to resolve disputes, the better. We also provide, upon request, a neutral facilitation to resolve the resolution meetings. And we also established a continuous quality improvement practice for our system, including participant survey, ongoing training for the roster, and feedback from our stakeholders. Thank you, Courtney. As we move on to our next slide. So in your packet that you receive, you will find the WSEMS brochure. The diagram on this slide is the same one that is on the first page of the brochure. The diagram shows the option that can be used to resolve disputes related to special education between parents and school and student disabilities and schools. With all 4 options listed in the dark blue arrows, parents and school will have control over the outcome as they are working together to resolve the issue. This is called self-determination. The lighter arrows show processes where someone else has control to make the decision. The informal meeting, which is the first arrow on the left, is not a process provided through us. It is simply a recommended meeting between parents, classroom teacher, principal, or special ed director. While it can be used at any time, it is especially effective if used early in the relationship between the parents and school. The other 3 dark blue arrows are all available through WSEMS, IEP facilitation, mediation, and the resolution process. In all 3, a WSEMS impartial mediator or facilitator can help the parents and school work together to reach an agreement that meets the educational needs of the student. In addition, all 3 WSEMS options start with a case intake by Gia Pionic. All 3 are voluntary, and all 3 are free to parents of students with disabilities and schools in Wisconsin. As you move from left to right on this diagram, the light blue arrows indicate processes that are available in Wisconsin, but not through us. And whereas the control of both the process and the outcome shifts away from the participants to someone else. For example, an IDEA complaint will be decided by Wisconsin DPI staff. A due process hearing will be resolved by an administrative law judge, and the litigation will be resolved by a judge or jury. Thank you, Courtney. As we move on to our next slide. So this is a visual that shows the case intake coordination process of WSEMS. So in the red box on the left, when a request is received for any of those three options available through us, and we mentioned mediation, IEP facilitation, or resolution meeting, it goes directly to Gia Pionic. She has no affiliation with any parent or school groups. She is not a parent of a child with disability and has never worked for a school. She provides an impartial approach to help parents and schools determine which option may work the best for them. In the purple box, in this part of the visual, Gia conducts a thorough case intake process. This includes screening, where Gia gathers information about the situation, including the child's name, age, the school district, the grade, the disability, disputes that have occurred in the past, contact information for both school and parents, etc. Gia also spends time answering questions and provides information to the parties about the different processes that are available through our system. And that's why the word education appears on that slide. And she provides information about the neutral, the mediator, facilitator on the roster, their styles, and answer to any question that the parties are asking information. Finally, at this stage, Gia uses all this information that she gathered to help determine if the case meets the statutory criteria. We are functioning under federal law, Individual Disability Education Act from 2004, in order for WSEMS to take the case, and this is why the word analysis appears on that slide. As we move to the blue box, through this process of providing information to the parties and answering their question, Gia helps them to better be prepared to make their own decision about what to do next. And in the green box, that's when parties have enough information from Gia. They are usually able to make their own decision as to whether to use the system and also decide which of the options will be best meeting their needs. The orange box simply reflects the options that are available through our system, IEP facilitation, mediation, and the resolution process. Thank you, Courtney.
Thanks, Nissan. So just to give a few details about mediation before we start to talk about the beginning, middle, and end of the process. So in Wisconsin, in a mediation, you have a trained impartial person who we refer to as a mediator or a neutral from the WSEMS roster. And that individual is going to facilitate discussion and is going to work to help the parties, so the parents and the school, reach their own agreement. Since IDEA 1997, which is the federal law governing special education, mediation is the dispute resolution option that is required by federal and state law to be available in states. And it's not just required to be available, but it's also required to be available for free to schools and parents. In your handouts, we've included something called the WSEMS Mediation Manual. That's the document that I referenced at the very beginning and said, be careful about printing that one out because it's quite lengthy, but it does have some really great information in it. It's got an overview of the process, and then it's divided up into 3 sections. You have a section for parents, a section for school representatives, and then a section for attorneys and advocates who may also be participating in the process. The manual is really helpful, particularly if you are considering going to mediation for an issue. A few other notes on the slide. You've got some references to some of the laws that regulate our mediation system. One of those laws that I want to draw your attention to is the one that talks about confidentiality. So that's 904.085. Confidentiality provisions are in both the federal and state laws, and they are really important to this process. Because the mediation process has to be kept confidential, we believe participants feel like they can perhaps better share more information, they can discuss different options, they can think a little bit outside of the box because the process is confidential. This also means that the mediator in the case may not be called upon to testify in any type of future legal proceeding. The other thing that we think it's important to mention related to confidentiality is that unlike in other states, WSEMS, through the stakeholder council that helped found the system, decided that the names of the parents and school districts who participate in mediation would not be shared at all. So the names of the parents and districts who are participating don't get shared with DPI. They don't get shared publicly with anyone else. They don't even get shared with Nissan and myself. The only person who has any knowledge of the specific names of participants is Gia, because she obviously collects that information as part of the intake process. The only type of information that is shared out publicly is cumulative information about, how many mediations were held in a particular year, how many facilitated IEPs, what was the agreement rate. It's overall information, nothing identifiable. Further, all parties are asked to sign a confidentiality provision before the mediation starts, again, just to make sure everyone is on the same page about the importance of confidentiality. And then just a reminder that discussions in mediation have to be kept confidential by everyone involved. And what that also means is that no records are kept by the mediator. So they're not going to be taking notes. Any notes that are jotted down have to be, cannot leave the mediation session. Everything in the session is confidential. And then one last, piece of information before we get a little deeper into the process is just to let people know that if you have used the facilitated IEP process, that's another option that's available through WSEMS. If you've used that process, you can still use mediation if you think that there's more work that needs to be done to resolve the issue. So just because you've had a facilitated IEP doesn't mean that you can't also eventually go to mediation. So with that, Nissan is going to share with you some information that's relevant before the mediation.
Perfect. Thank you so much, Courtney. So mediation is best used when help is needed to settle a specific dispute. For example, a disagreement about the need to use a paraprofessional in the classroom, or the amount of time that the student needs speech and language throughout the week, or the amount of time the student should participate in the resource room versus the regular education classroom. A very specific dispute being identified, and that's where mediation is best to use, or best to use when there is a poor communication between the party, or there is not a very constructive or has not been productive or constructive in the past. Or best to use it when there seems to be an impasse has been reached, where discussion has hit a brick wall and there's no movement forward. Or perhaps when there is a strong history of dispute between parents and school and there's lack of trust between the parties. And that's where a professional mediator is best used. The other advantages for using mediation, it offers the possibility for creative, flexible solutions, sort of thinking outside the box. It's also another advantage. It is forward-looking process. It focuses on the future, rolling the sleeve and seeing what can we do now to improve the situation rather than concentrate on the past and all the grievances that come from the past. It is also cost savings. It resolves itself quickly. It avoids time and expense of preparing for participation in legal proceeding of a due process hearing. And the most important part is the parties, the parents and the school are the decision makers, as well as a chance to preserve a good relationships. Perhaps the most significant impact of mediation is establishment of a collective partnership that not only helps in resolving the present dispute, but also provide parents and school with a framework to resolve future disputes. In addition, every step of the mediation process is voluntary. You only participate if you want to, and you can stop anytime you want to. If a parent requests mediation, the school doesn't have to agree or vice versa. And no one other than GIA knows which parent, which school districts request mediation. And as Courtney mentioned, based on our WSEMS protocol of operation, Courtney and I are not allowed to have this information, and all in an effort to maintain parent and school requests confidential. Thank you, Courtney. As we move on to the next slide. So, to qualify for mediation, a referral to special education must have been made. The issues that can be addressed in mediation may include such disagreement regarding the evaluation of students. Say the parents do not agree with the results of a certain evaluation, or disagreement regarding placement of students in particular programs, or maybe the disability determination of the IEP team, obviously any IEP-related issue, and then the provision of FAPE. FAPE stands for Free Appropriate Public Education. FAPE also means providing students with disability access to their grade level curriculum. A student with disability in 6th grade who reads at the 2nd grade level does not have access to 6th grade level books. Without access to grade level books, the student cannot make progress and advance from grade to grade as the law requires, as well as was stated by the U.S. Supreme Court in its Andrew F. decision in 2017. Thank you, Courtney.
Thanks, Nissan. So let's move on to how one goes about requesting mediation. So on the screen, you've got a somewhat blurry visual of the request form. We've also put the request form into your handouts, so you have that as well. A request for mediation has to be done in writing, and it has to be sent to the WSEMS office. Now, usually the quickest way to get a mediation going is through what's called a joint request. A joint request happens when both the parents and the school sign the request form and then send it in. So it comes into GIA signed already by both sides, indicating that they are electing to participate in the mediation. So that's the quickest way to get things going. However, you are still able to request mediation with just one signature. That's what we call a single request. So that means either the parent or the school fills out the form, they sign their portion of it, they send it into GIA. The reason things take a little bit longer with a single request is obviously because since mediation is completely voluntary, GIA is going to then have to take the step of contacting the other party to see if they are interested in participating and moving forward. So you want to use this form. This form can also be found on the WSEMS website as well. There's a small space on the form that asks you to briefly describe the dispute. And when we say briefly, we mean it. It could be something as simple as just saying transportation issues. And the reason you don't have to include a whole lot of detail on the form is because when Gia does that intake process that Nissan talked about a few slides back, she's gonna be able to, get way more detailed information over the phone through the intake process. So you just don't need to be verbose in that section on the form. And then once both parties agree to participate in the mediation, the next step is for them to both agree on which mediator to use. So that's what our next slide talks about. So who are the mediators that do these mediations? Well, in some states they have just a few. Other states have very, very long lists of mediators. Some states use community mediation centers. Some states use administrative law judges. Some states even use their state employees. Here in Wisconsin, we are a little unique. We have our own roster of about anywhere from 16 to 20 neutrals. Those individuals are contracted through our system to serve as mediators. They are not our employees, which means that Nissan and I, we're not their bosses. They are contractors with the system. And the neutrals on our roster who do the mediations are also used for IEP facilitations and for resolution meetings. We believe that a key component to a successful dispute resolution system is having truly impartial mediators. So what that means is that none of the mediators on our roster are employed by a state education agency, so like a DPI. They're not employed, none of them are employed by school districts or local schools. And the same goes for parent organizations. None of the mediators on the roster are employed by or volunteer for any type of parent advocacy organizations. And again, the reason this is so important to us is because we want schools and parents to both feel comfortable with the mediators that we have on our roster. In terms of how mediators come to be on our roster, we do get that question from time to time, so it's probably worth giving a little bit of detail. It's a pretty involved process. There's an application and an interview process. We also look at an extensive amount of training for each individual who is interested in becoming a mediator on the roster. One of the things that we look at specifically is the amount of experience that individual has with doing mediations. And we don't just look at people who have special ed mediation experience. Our roster is quite diverse, and we have mediators on our roster with a very broad range of professional backgrounds and varied experience. For example, we've got mediators who have previous experience doing elderly mediation, doing workplace mediation, even some who've done labor and farm mediation. We think it's important to have a really wide spectrum of experience. So once someone is selected to be a mediator on our roster, they are expected to attend annually an update training that the system provides to them. And that's the way that we make sure that the mediators continue to stay up to date on topics, trends, laws that may impact the mediations that they're doing. So when it comes to selecting a mediator, either party, so the parents or the school, can suggest a specific mediator, and they can do that by just writing the mediator's name on the request form, or they can just verbally communicate that to Gia when she does the intake. If the parties don't have a specific mediator to request, or if the parties are having a hard time agreeing on the same mediator, Gia is going to be there to help work with the parties to help them find a mediator who both, again, the parents and the school will find acceptable. And you've got the link on the screen to the website. On the WSEMS website, under the portion of the website for mediators, there's each mediator has a bunch of information there. Some of them, you have bios and pictures and even videos of some of the mediators. So if you are thinking about mediation as an option and you are wanting to check out what might be available, that would be the place to go for more information. So I will pass things back to Nissan.
Thank you, Courtney. So mediation will be scheduled within 21 days of the request. The mediator works with the parents and school to schedule the meeting session for a date and location that's convenient to both. So everyone can feel comfortable, safe environment. Could be in a public library, community center, a bank, a school, etc. Mediation usually takes part of a day, and some parties may need an additional session if the issue are very complex. However, the average is about 4 hours. The mediator also asks the party to identify who else they would like to participate in the mediation. Our Wisconsin statutes provide that mediation participants automatically may include 2 parents or competent adult student and 2 school representatives. Since school representatives were not defined further, one of them potentially could be a school attorney. Per our statutes, other people can participate, but the parties, the parents and the 2 school representatives, must agree to those additional people. So, for example, any other people that parents would like to have, like relative, neighbors, advocates, attorneys, for example, must be approved by the school. On the other hand, additional people that the school feels should be included, such as educators, IEP team participants, must be approved by the parents. If the parties have been working with attorneys prior to the mediation, it is usually better to have the attorneys in the room so they can hear the discussion. Otherwise, the attorneys will be consulted after the meeting or during the meeting by phone or email. It is advisable to have them at a meeting, since as attorneys, they can provide legal advice while mediators are not allowed to give legal advice. Having said all that about attorneys' presentations in mediation, it is important to note that while over the last 20 years, about 1/3 of all of our mediation included attorneys for both sides, and 2/3 of our mediation cases did not include attorneys, yet the agreement rate of 85% to 90% is the same, whether attorneys participate in mediation or not. While setting up the mediation session, the mediator generally also asks the parties to agree on how much time they have available to meet. There may be a few hours or all day, depending on what the parties decide. Thank you, Courtney. As we move to the next slide about the mediator's role. The mediator helps the parties confirm who will participate in the mediation session. GIA helps them make the initial decision. The mediator spends time to make sure the parties understand what to expect for mediation. The mediators help facilitate the structure of the discussion between the parties during the mediation session and uses interest-based negotiation. This simply means the mediator are searching through their questions for the interests that are behind the position taken by the 2 parties. When the interests are known, mediator finds it easier to come up with a win-win solution. We are training our mediators so they have a working knowledge of special education process. They should have knowledge about the terminology that we use in special education and about the most current issues like open enrollment, voucher, virtual learning, additional services, etc. However, the role of the mediator is not to impose a decision, nor can they give legal advice, as we mentioned earlier, or interpret law during the mediation session. Their role is simply to help the parties resolve their dispute and reach an agreement that both parties could live with. Thank you, Courtney.
So, what happens in a mediation? Well, the mediation process is largely very formal. Most of the time, everyone is in the same room for some, if not all, of the mediation, though sometimes a mediator can meet with participants separately. This is called a caucus. At the start of the mediation, which sometimes is referred to the opening, the mediator is going to go over what's called the agreement to mediate, and that is also one of your handouts. As a part of going over this, the mediator and the parties are going to review the confidentiality provisions to make sure, again, everyone's on the same page. And then everyone present is asked to sign this agreement. This agreement is not indicating you agree with the outcome of the mediation. This agreement is simply done at the beginning, saying, yes, I'm here voluntarily, and yes, I agree to abide by the confidentiality provisions. So next, the mediator, most of the time, is going to move on and explain the process and what their role is in the process. The mediator may also ask the participants to explain why they are there, maybe what they would like to see as a positive outcome to resolve this dispute. The mediator is likely going to ask a lot of questions so that they can clarify information. They may engage with some brainstorming, and they're also going to help the parties try to identify some options. During the mediation session, there is no audio, video, or written record of the session itself. A little bit more information about the session. So we like everyone to know that during the session, anyone can ask for a break at any point in time. And sometimes the mediator themselves may decide it's time for everyone to take a break. It's also important to remember that the focus of a mediation is on resolving the issues and deciding on goals for the future, not looking to figure out who's to blame for what may have happened. So it's really important that participants to a mediation come and commit to working in a collaborative tone, because again, the process itself is very forward-looking. How can we resolve the issue? How can we move forward? How can we put steps in place to better support the student themselves? A few things we like to mention about communication as it relates to mediation. So first, just a reminder, one of the goals of mediation is to have enough time to have the other party understand what someone's feeling, why they're feeling, how they feel about the issue, and then to also have the other party have that same opportunity to really express where they are at with things. Sometimes, the mediations can involve a lot of emotion, understandably. And so the parents or the school may find it difficult at times to express these thoughts, especially if they're, in a room with all of the other participants. So again, It is certainly the right of each party to ask for a private session with the mediator. Again, that's called a caucus. And during this time, the mediator can be helpful and can provide some assistance to help people frame their ideas, maybe in a way that the other party would be able to better hear them or receive them. In other words, the mediator may work with the individual to help them think of a way to present their thoughts in a meaningful and understandable way. Because again, the goal is to make sure that each party knows where the other party is at with things. It's really critical to listen carefully during the mediation to what other parties are saying. It's okay to ask questions of the other party if something is not clear, or if you have questions that are maybe uncomfortable to ask directly in an open session. That might be something else that could be shared with the mediator during a caucus. I have some questions, I'm not comfortable asking them directly. Could you help me ask these questions? With that, I will toss it back to Nissan.
Thank you, Courtney. So the mediator's job is to help the parties negotiate. Mediation gives the parties the opportunity to be creative and flexible. Bringing many ideas to mediation and being open to multiple solutions help you to reach an agreement. It is important to try not to be positional, sticking to just one position or idea, and try to avoid being competitive. The mediator is often helpful in providing a reality check for the party to think about, usually done in caucus, that is in a private meeting, on what realistic alternative there may be if people walk away without an agreement to resolve their issue. Thank you, Courtney. As we move on to this slide, you see the picture of Nina Meyerding on the slide. Nina Meyerding is a former WSEMS mediation partner. She is an international leading authority on dispute resolution who conducted over 5,000 mediations. Nina recorded several short videos posted on our website, WSEMS.us, on how to be an effective participant in mediation and in IEP facilitation, and how to address high emotion that occur in IEP facilitation, as well as other videos. You can access these videos by going to our website, WSEMS.us, and click on the Multimedia tab. Thank you, Courtney.
Thanks, Nissan. Yeah, those videos are really good. I would definitely encourage checking those out if you have an opportunity. We want to talk a little bit about the mediation agreement. So if the parties work together during the mediation and are able to arrive at some type of agreement to their issue, they would form what's called a mediation agreement. This is something that definitely needs to be written down. There is not a specific form you use to document this. And sometimes people are kind of bummed out by that because they think it would be easier to just fill in a form. The reason that there is no standard form is because every mediation agreement is really unique and different, and it's very specific to the particular parties and issues that mediation dealt with. So it would almost be impossible to have a form that would be applicable to every mediation. But so we ask the parties themselves to write down their agreement. And we encourage parties to be very specific when they're doing this. So things like who is going to do what, by when, how, if other individuals that are not at the mediation are going to be involved in this, it's very important to indicate who those individuals are. If there are any other pending processes, like a due process hearing or some type of IDEA complaint or an Office of Civil Rights complaint, anything like that, it's really important in the mediation agreement to indicate if because of this agreement, the parties are agreeing to withdraw from whatever else they've got going on. So let's say there's an active due process hearing request. Are the parties agreeing to withdraw that request because they've come to an agreement in mediation? We also recommend that parties include a statement that they can go back to mediation if things start to fall apart. We don't see this happen too often, but it certainly is a possibility. And going back to mediation to figure out, what's going wrong here is certainly allowed for. The only mandatory language that has to be in the mediation agreement, it's on the slide, it's in italics, but I'll read it to you. All discussions that occur during mediation are confidential and may not be used as evidence in any hearing or civil proceeding. So that's the only thing that is absolutely positively required to be in a mediation agreement. Another thing to consider when you're putting a mediation agreement together is a plan for how to share the information. So obviously, there are likely going to be people who are impacted by what's been agreed on who weren't part of the mediation session. So how is that information going to get to them so that they know what role in all of this they have? We do not ever recommend that a mediation agreement be attached just simply to an IEP. And again, that's because we are trying to maintain confidentiality. It's important to understand that your mediator can't give you legal advice. They're not going to be drafting this agreement for you. That's not their function as a mediator. However, if there is an attorney participating in the mediation, an attorney can be quite helpful sometimes in putting these agreements together to make sure that they're comprehensive and they cover everything. Certainly either party or both parties can have an attorney review the agreement. That's absolutely fine. Another thing to note is that the only people who get copies of the mediation agreement are the parents and the school. The mediator is not going to keep a copy of the agreement. DPI will not have a copy of the agreement. GIA, the intake at the system, will not have a copy of the agreement, just the parties. And then last but not least, in Wisconsin, a mediation agreement is considered legally binding. So that's actually, when you're putting this agreement together, you are forming a contract between the parties to do what is spelled out in the agreement. Before we leave the topic of a mediation agreement, though, I think it's important to highlight that we hope people don't lose faith if they are not able to reach an agreement at the end of a mediation. Oftentimes, just going through the process of the mediation can be very helpful. It can help parties identify issues that they maybe weren't aware of. It can help build the communication between the two parties. And sometimes what happens is that parties may be able to reach what's called a partial agreement. So they are agreeing on maybe smaller or subparts of an issue, just not everything that was tackled during the mediation. And that can be very valuable for that to happen as well. All right. So the next couple of slides are going to talk about what happens after a mediation. Few things to note that, and some of this is just actually a review, the WSEMS office is not going to keep a copy of the mediation agreement if you do reach an agreement. So it's really, really important that you hold on to that agreement. WSEMS does also not have any responsibility for enforcement of the agreements. So if for some reason one party feels like after the mediation the other party isn't, living up to their end of the agreement, unfortunately WSEMS cannot come in and compel anyone to to abide by the agreement. What we can share with you is that if things do start to get kind of rocky, even after agreement is reached, parties can both go back to mediation if there are concerns with follow through or if new issues arise. So that is definitely always an option. And then we are going to close things out with just a little bit of information about some of the achievements of the system over the years.
Thank you, Courtney. So as you can see from the slide, all the participants in mediation are asked to complete a confidential survey about the session. And the survey helps us then determine the effectiveness of the system and essentially our quality control. And as we move on to the next slide, we can see the results of the past years of the mediation. So through 2020, we have had almost just a little bit over 3,000 participants. And you can see from from this information that almost 90.4% of the participants were satisfied with the mediation process, and about 92% will use mediation option again. And in fact, over 90% will use the same mediators again. And we have nearly 90% rate of written agreements, meaning agreement of that resulted from the mediation. And you can see at the length of the mediation process, about 4 hours, as we mentioned earlier. So as Courtney mentioned before, this is the only information that we share in public or with Wisconsin DPI. One of our strengths is the reliance on confidentiality. So no identifiable information is made available anywhere or to Wisconsin DPI or to even Courtney and I. Only GIA and the mediators are aware of who they meet and who are involved in the mediation process. Thank you, Courtney.
Thanks, Nissan. So just a quick note about some outreach that's available to everyone from the system. So myself, Nissan, and Nelsinia, we do most of the outreach. We have a really great website. If you haven't had a chance to do some exploration there, I would highly recommend what's on the website. The other nice thing about the website is we maintain a mirror image of the site in Spanish, so everything that's available in English is also available in Spanish. All of the forms that you might want or need for the system can be downloaded from the website. There's a lot of information about the actual mediators themselves. And then there's some great, on the multimedia tab, there's some great videos to watch too. We also do a great deal of material dissemination now that conferences are starting to happen in person again. We are usually have an exhibit there to help push information out. And last but not least, we do webinars just like this one for anyone who is interested in learning more about the system. And certainly if you work with a group, a school, a group of parents, and would like to request a training for that group, Nissan and I are your contact people for that. So I will toss things back to Nissan to kind of bring us home here.
Thank you, Courtney. So mediation, as we have seen, is a participatory process that has flexibility in both process and outcome. It helps create agreement that work for the parties and therefore have a greater chance for durability over time. It encourages collaboration and importance of good working relationship between all the parties for the best interest of the child. And that should lead us to our Q&A and evaluation. Thank you, Courtney.
Thanks, Nissan. So I will pause for a moment to see if any questions come in. None have come in throughout the rest of the workshop. I have been monitoring. If you do have a question, you can type it in the question box, or you can press the little hand button next to your name if you want to come off mute and ask something verbally. So I will pause for just a moment. Okay. Ooh. Kathleen, if you want your line unmuted, raise your hand one more time. It went up and down real quick. Okay, great. So Kathleen, you are off mute.
Okay, I just picked up something about the level of the class of the books in the classroom, and I just kind of barely heard that, and I'm just wondering if you can elaborate on that.
Of course, of course. Thank you for the question. So, free appropriate public education means that students with disabilities should be provided with access to the grade level curriculum.
Right.
And for example, if you have a student who is blind, obviously he or she will need Braille to be provided with access to the grade level curriculum. And the same applies to all other disabilities. IDA 2004 invested a great deal of money in something called NIMAC, the National Instructional Material Accessibility Center, that includes thousands and thousands of source files for printed books in education that allows students with disability, for example, who do not read at grade level, to use those either Braille or text-to-speech or audio files or large fonts to be able to access their grade level curriculum. Because IDA 2004 requires students to make progress and to advance from grade to grade, and you can only do that if you have access to that grade level, to your age or grade level curriculum.
Okay, so if I've got a child that's reading consistently like 5th grade level, and they're in science in 9th grade, there needs to be some, and my child is an EBD child. She's not a special, she's not learning disability, but she's EBD. But they need to provide then the material that the class is doing at a grade level that she can handle. Is that what I'm understanding?
That is correct.
And they do that using text to speech, which means, what does text to speech mean?
Sure, that means a digital text. So they can use software, for example. That's one option available. The IEP team would have to conduct an evaluation to determine if the student is a good candidate to use text-to-speech, for example. That's one option. There are several others, and assistive technology specialists are available to assist IEP team members with this decision.
Okay, so if I want to know what options there are available, I would go where? Do you have a website or something? Assistive technology?
I would check with your local school district special ed director and inquire about that.
Okay, all right.
Thanks, Kathleen.
Okay.
We are over time, but 2 questions have come in. I want to just put out there real quick, so if anyone needs to drop because we're over time, I understand. A question has come in about how WSEMS can help after a complaint to DPI has been made. I want to be clear that the DPI complaint process is very separate from the mediation process. So if there is an issue that is being experienced between a family and a school, mediation is always an option, regardless of whether an IDEA complaint has been submitted. But the mediation system is unfortunately not available to try to enforce whatever, if DPI has reached a decision about a complaint, the mediation system is not the venue to try to enforce whatever decision DPI has made about that complaint. However, if an issue still persists, mediation may be an option. And then there was another question that came in about the resolution process. The resolution process is a different process than mediation. The resolution session is a meeting that is triggered once a due process hearing is requested. So the resolution process does not exist until a due process hearing has been requested. And Nissan talked really briefly at the beginning of the workshop about that meeting. That's essentially just a meeting between the family and the school. It's kind of one last attempt to try to resolve a dispute before a due process hearing actually begins. One option that is available, unfortunately, during a resolution meeting, the meeting itself does not have any legally mandated confidentiality provisions. So what you may opt to do instead of a resolution meeting, you may opt to go to mediation instead, because the mediation does have those confidentiality provisions in place. So they're separate processes, but we do offer a facilitator for both resolution meetings and for mediations. So I hope that answers those two questions. No further ones have come in, and like I said, we are over by a couple of minutes. So at this point, we are going to have to conclude the webinar. I'd like to thank everyone who hung with us, and also a hearty thank you to Nissan Barlev for co-presenting today's workshop with me. Okay, at this point, we are going to conclude the webinar. Thanks, everybody. Thanks, Nissan.
Thank you. Bye-bye.